I hope this finds you well. Today we're going to look at the common law rule for defamation and how slander and libel play into the defamation rule. The landmark Supreme Court case is New York Times versus Sullivan. We won't go too in depth with New York versus Sullivan in this video, but I do intend to create a case brief for New York Times versus Sullivan in the near future. So let's look at the elements of defamation. There's either 4 or 6 elements when trying to prove defamation. Your regular run-of-the-mill defamation has only 4 elements, and when the defamation concerns a matter of public concern, well, then you get the 2 other layers of defamation. So here are the elements. There first must be defamatory language. It must be of and concerning the plaintiff, which is the person bringing suit. Publication of that defamatory statement by the defendant to a third person. And then there must be damage to the plaintiff's reputation. As I previously said, if the matter is of public concern, meaning something that the public would find value in, then 2 other elements must be proved, and that is falsity of the defamatory language and fault on the part of the defendant. So let's look at each element and break it down. When it comes to defamatory language, the meaning of defamation is anything that really harms a person's reputation. Next, we come to the of and concerning the plaintiff. The defamatory statement must relate to the plaintiff. It can't be about the plaintiff's sister, the plaintiff's brother. It has to be about the plaintiff. And there's an interesting little side twist in there when it comes to groups. So a group can bring a lawsuit for defamation if a defamatory statement refers to all members of a small group. A good number to keep in mind is about 15 people or so. If the statement is about a large group, then no member can really prove that the statement is of and concerning them. And finally, if the statement is about some members of a small group, well, then the person bringing the defamation claim may be able to show that a reasonable person could view the statement as pertaining to the plaintiff. Next, we come to publication. Publication is really a term of art. It doesn't necessarily require that the statement be posted on the internet or written or published in a book. It's really any kind of communication by any method when it's communicated to one or more people who actually understand it. So if you're at a party and everybody in that party speaks English, except you and your friend who speak Portuguese, and you scream out in Portuguese something defamatory about your friend, well, you did publicize it, you did make a publication, and it was to a third person, but it wasn't able to be understood. And publication can either be intentional or negligent. Intentional publication is where the defendant's intent was to defame this person. They intentionally spoke something or wrote something about the plaintiff. Negligent publication, for example, occurs when an individual types up a defamatory email intending just to save it on their computer, let's just say. Well, mistakenly, they press send and it goes to the whole entire company. Just an example. And then you must show damage to the plaintiff's reputation. Now this is where our slander or libel comes in. The easy way to remember the difference is I like to look at the S and take the S in slander, and that's how I keep them separate in my mind. Slander is spoken, while libel is written defamation. And whether the defamatory language is slander or libel really goes to the heart of damages and what kind of damages that the plaintiff can recover. So for libel, which is our written defamation, the plaintiff does not need to prove any kind of special damages or general damages. Now that's not the same for slander. When it comes to slander, which is our spoken defamation, the plaintiff's going to have to prove special damages. Unless that defamation, that slander, falls into one of 4 categories or one of 4 types. The first type being that the defamation reflects adversely on business or professional conduct. The second being that someone has a loathsome disease. The third, that someone is guilty of a common law crime or a crime of moral turpitude. And finally, it's defamatory to accuse a woman of being unchaste at common law. Okay, so our other two elements, the falsity and fault, come into play when there's a matter of public concern at the heart of that defamatory statement. You still must prove the four elements we just spoke about, but then you have to ask yourself, can the plaintiff prove that the defamation was false? If they can, then you have to prove fault on the part of the defendant. Here's where it gets a little hairy. If the plaintiff is a public figure or some sort of public official, then this is where the New York Times versus Sullivan comes in. You have to prove actual malice on the part of the defendant. If it's a private individual, someone unknown to anyone, well, you can either prove there was actual malice on the defendant's part or there was negligence on the defendant's part. So that's how we prove defamation. But there are some defenses the defendant can raise, and these are known as privileges. So our absolute privileges are the executive privilege, and this concerns communications by the president as well as some other members of his executive branch. Judicial privileges, and these are protections from comments by a judge or a lawyer or parties or witnesses, but the comments must be made and related to the case, the ongoing case. And then there's the legislative privilege, and this privilege applies to the legislative branch of government. For example, if the speaker is participating in a legislative proceeding. And then you have your qualified privileges, and there's three of the qualified privileges as well. You have a privilege to protect yourself, protect others, or protect a group or common interest. When protecting yourself, the speaker may make a statement in order to protect their own personal interests. For example, if you're walking down the street and someone picks your pocket, or you believe someone picked your pocket, and you point to someone in a crowd and say, "That man stole my wallet." Well, you may be mistaken, but you had a privilege because you were protecting your personal interest. You have a privilege when you protect others, when the speaker is actually trying to protect some other person's interest. For example, a lady thinks she saw someone steal your wallet, and she says in a crowd, "Hey, that man just stole his wallet." Finally, there's a protection for the group or common interest. And this occurs when the speaker makes a statement to protect the group that he or she is a member of. And this can occur with your resumes and references. All of these qualified privileges kind of fall into that protecting interests. Finally, the qualified privileges can be lost, and they can be lost when they are abused, such as excessive publication or making a statement with malice. Then they're not going to apply anymore. Thanks for watching.